All right, let's go to Gonzalez versus Estate of Emiliano Garcia.
Good morning, Your Honors. May it please the Court, Jacobeli Behar from the Nguyen Law Firm on behalf of the appellant, Antonio M. Gonzalez. I'd like to reserve 2 minutes for rebuttal.
All right.
Your Honors, the order under review invalidates the last will and testament of Emiliano Garcia, dated December 6, 2017. Now, in that order, and without any legal challenge filed to the validity of the December will, the trial court disregarded the plain language of Section 732-502, which gives us the execution requirements for a will, and the evidence presented establishing the will to invalidate it based upon the form of the will used by the testator. At its heart, the central issue of this case is the role of the execution formalities in the admission of a will to probate, but the bigger picture is the ability and the right of all Floridians, no matter their level of sophistication or ability to hire a lawyer, to make a will that devises their property after death the way that they want. We believe that the court erred below in failing to recognize the evidence establishing the December will as the validly executed last will of the decedent, and by construing the will prior to its admission to probate, which is explicitly prohibited by 733-213. We also find error in the court doing this without any challenge made to the will, which clearly violated the due process rights of the appellant to have notice of the issues to be determined. Now, in order to determine whether a will should be admitted to probate, the probate court has to determine whether the will was validly executed with the formalities provided under Florida law. The evidence presented to the probate court established that the December will satisfies those requirements.
But is it your position that the trial court should have submitted both wills to probate?
No, Your Honor, because
we had 2 competing wills here, right?
That's true, Your Honor, but we had actually filed an answer to the petition for administration filed by the appellee challenging that will on the basis of undue influence and lack of capacity.
But you were challenging that will, but we had 2 competing wills, so only one of them could go to probate, right?
That's correct, Your Honor, but a will cannot be admitted to probate if it's been revoked by a later will, and that's the situation that we submit we have in this case. The later will names Antonio M. Gonzalez as the decedent's, quote, absolute inheritor.
Did it affirmatively revoke all prior wills?
There is language on the 3rd page of the will that affirmatively revokes all prior wills, but what I would say is that this is not the prettiest will in the world. This was a pre-printed commercial will packet, and so the decedent failed to fill out certain blank lines throughout this packet and went to the second to last page, which was titled Statement of Wishes, and that's where he handwrites and the witnesses.
Well, it's not just certain areas, right? We have a number of different blanks on the document, right?
Absolutely, Your Honor, but the witnesses were also asked to flip through the document and confirm that this was the same packet that they witnessed the decedent sign on the date of execution, and they did confirm that, and that was also stipulated to the order of pages by the appellee in the hearing below.
Wasn't the trial judge required to make an evidentiary determination as to which will was valid before submitting the matter to probate? Because she had to pick one will to submit to probate, right? You can't have competing wills, so she had to determine the validity of one.
Yes, that's correct, Your Honor. But she didn't get to the second petition for administration during that hearing. Really, there was only enough time to get to our petition for administration. So that second petition for administration is actually still pending today, and there's a hearing scheduled to determine whether that will is valid or not. But the central issue here is that if our will revokes the earlier will, which even if even if the trial court found that its explicit terms did not revoke prior wills, the inconsistent terms used in the will, naming Antonio Gonzalez the absolute inheritor, would revoke the previous portion of the October will that states that Mr. Santana should be the sole beneficiary. So what you have here is a will that, in any event, it states revokes all prior wills and also has language that would revoke the language of that prior will ahead of an earlier will, which is still being challenged for undue influence.
So is it your position that this was, I know you said in your brief it was premature, but this is premature because if there's a finding that the prior will was invalid, then this may have more legal significance than what the trial judge attributed to it?
Well, I think it's premature because the court went to the language of the will and construed it and found it to be invalid based upon the language. And clearly the statute, the case law, could not be more clear. It says that you cannot look at the terms of the will and invalidate it based off the court's construction without admitting it first. So what the trial court should have done, respectfully, was admit the will to probate, and then if there was a construction action, which there wasn't any petition to construe the will filed at the time of the hearing, and there still is not one, then at that point the court could have looked into the terms of the will and determined who the beneficiaries are, for instance, who the PR would be. But that's a labor for after admitting the will to probate. And so when it comes to whether the will should be admitted, we look towards the execution requirements because that's the legislature telling the people of Florida, this is how you make a will.
But there is a problem with the execution here, it seems to me, although you indicated this might have been stipulated around, but
Okay.
the document you're relying upon, it's multiple pages, but the crucial page is Statement of Wishes, which is numbered 1 of 1. The self-approving affidavit with the supporting signatures is page 13 of 13, so there appears to be 12 pages missing.
Well, Your Honor, that's actually not
Which
true.
then raises the question as to whether page 13 was affiliated with the Statement of Wishes or perhaps another document.
Well, page 13 of 13, I'm glad you brought up that point. There's actually a number of pages throughout this commercial will packet that say 1 of 1 that are out of sequential order as the packet came, but the packet came bound, and that was a fact that was stipulated to in the court below, and there was no competent substantial evidence presented by any party to say that these documents were not bound together, that this was not the complete will, and the witnesses clarified that issue when they testified. They were asked to flip through the pages of the will, confirm that this was all the same document, and if you look at the self-proving affidavit, that's the only page that the witnesses signed. So they're witnessing the decedent sign his will, and they're signing on that self-proving affidavit. They also testify that they witnessed the decedent write in the terms on the Statement of Wishes page. So not only did they witness him sign his will, they witnessed him fill out his will, and that was established in the hearing below.
So there are some facts that support your position, but isn't it also a contrary fact that there appears to be 12 pages missing? Even though you have testimony, well, gee whiz, there's a good explanation for the missing pages, but on its face, it looks like there are 12 pages missing, and so this document, the self-proving affidavit, may or may not be associated with the Statement of Wishes.
We don't believe that to be the case, and if you look at the first couple pages of this commercial will packet.
Again, I'm just looking at,
Yeah.
is there any conflicting evidence? I'm not the finder of fact, so we're just an appellate court. The trial judge below apparently found a problem. If there is conflicting evidence, we yield to her determination.
Well, she only found that, she didn't find that problem or make that finding of fact based upon any evidence that was presented to her. In fact, the appellee presented no evidence at the hearing. We brought our witnesses, and there's a self-proving affidavit, so you don't technically need to bring the witnesses.
Is the discrepancy in the pagination a sufficient fact that the trial judge could rely upon?
We don't think so, no, Your Honor, because the witnesses actually came and testified that and upheld the terms of the will. So they came to court and talked about the fact that they actually signed this thing. They watched the decedent fill this packet out, the same packet that was present at the hearing, and they were asked to flip through it. They confirmed it. So there's no evidence that the trial court can really base that finding on other than this mispagination. And again, this is a pre-printed commercial will form. The packet came as it
We're working
came.
into your rebuttal time, so if you'd like rebuttal,
Reserve.
all right. You have a minute. You have 90 seconds left.
May it please the Court, William Mueller of the law firm Kula & Associates on behalf of the appellee. The probate court in this case revoked temporary letters of administration based upon the document that the appellant submitted to it purporting to be the last will of the decedent. Both sides agree that the dispositive case law, the dispositive analysis is the four corners rule. Is this document a will? First, threshold issue before we decide what it means, whether it has any legal significance. Does this document contain the essential elements of a will? That is what the probate court reviewed at the evidentiary hearing. That is what the probate court determined constituted revoking those temporary letters of administration, which of course appoint a PR, which this document does not allow any sort of legal sufficient basis to do so. And that's where I'd like to begin, frankly. Let's look at this document. What was actually submitted to the probate court? What is this purported December will? Because this court has already identified several shortcomings of that document. Allow me to provide a few more. This is a fill-in-the-blank will. The first 17 pages are a fill-in-the-blank will where not a single blank was filled in by the decedent. That includes the decedent's own name on page 4 of the document. That includes any of the individual bequests that the decedent wanted to make, pages 5 through 8. And that crucially here means that the space appointing a personal representative was left blank as well. The only page in this compendium of items that was submitted to the probate court that was filled out was the statement of wishes page, which is that page 1 of 1 that Judge Logue referred to. And that statement of wishes page has certain prefatory text that we need to interpret just as much as we need to interpret what was written down purportedly by the decedent.
And as we do that, what is our standard of review?
Well, Your Honor, interpreting the four corners of that document will be a de novo review. However, that document, the will itself, the testimony at that evidentiary hearing is going to be reviewed by this court, giving full deference to the trial court and this court, probate court's findings of fact. And of course, that testimony that was alluded to earlier today was rejected by the probate court. And I'll get to that in one moment, but I just want to continue on with the document to see exactly what the probate court was thinking in this case.
So what problems are in the statement of wishes?
Well, two problems really, and if I could read, the statement of wishes specifically says, I, the decedent, do hereby set forth certain wishes and requests to my personal representatives, heirs, families, friends who may carry out these wishes. And now it has this precatory disclaimer that says, I understand that these wishes are advisory only and not mandatory. And it's that disclaimer that's going to distinguish this precatory language from other case law that says that sometimes when there is some sort of wish or request made to a PR, we're going to interpret that as mandatory. In those cases, I guarantee you there is not an explicit precatory disclaimer here that we have to interpret per the four corners rule and harmonize those prefatory statements with what was written by the decedent below. So we continue on with the probate court's analysis. Is this document a will? Under the probate code, a will has to do two things. It has to, A, dispose of the decedent's property, and B, it has to either appoint a PR or revoke a prior will. Does this document do that? That was the threshold analysis that the probate court underwent here. And the only page that's filled out that might dispose of property is that statement of wishes page. So does this discretionary request made upon a personal representative, family, friends, constitute a disposition of property? No. The case law says you need to create a mandatory obligation in order to dispose of property. You cannot wish that to be so. That disclaimer was not scratched out by the decedent. That disclaimer was not crossed out at all. He chose, out of these 24 blank pages, to fill out the one page that was extremely conditional and discretionary. He could have effectuated a mandatory transfer of property by filling in 4 blanks in the fill-in-the-blank will on pages 3, 4, and 5. He could have done that with 4 words, 4 names, chose not to do that, chose to fill out the one page that is statement of wishes. Now, we don't know why he did that, but we led into this evidentiary hearing that was conducted by the probate court, who received this document and said, I don't think this document's a will, so I'm going to hold an evidentiary hearing so you can come forward and tell me that what's written on this page means something more than what's actually written on it. At that evidentiary hearing, 2 of the 3 witnesses to the will came and testified. They all were intimately related to the appellant who would stand to benefit from the effectuation of this will. They were his father-in-law and his son-in-law. The notary was the childhood friend of the appellant's wife, and they all testified that they had no relationship to the decedent. They said explicitly, we're not friends with him, we're just neighbors. And he called us over to sign a will. So the probate court, as the finder of fact, as the assessor of testimony, rejected that testimony as unconvincing and said, I don't believe it. What I actually believe are these pages that are written on this document. Page 13 of 13, as Judge Logue pointed out, is that self-proving affidavit, even though it's page 24 of the document. all of these individual questionnaires are pages 1 of 1. This seems like a hodgepodge of a unrelated assortment of items put together, and then these witnesses came in and testified rejecting that testimony. Of course, that's a factual assessment that's solely and uniquely within the province of the trial court, who was privy to their demeanor, their eye contact, the tenor of their voice during that evidentiary hearing. Probate court rejected that testimony and instead relied on what's in the 4 corners of this document, which do not contain the essential elements of a will. And so, yes, there is still a pending petition for administration based on my client's will that is still subject to its own evidentiary hearing to make sure that it was validly executed. But this is not a case as to whether or not this document was witnessed or notarized. Even if we were to believe the witness's testimony, let's say this document was witnessed and notarized. Is it a will? Is a statement of wishes in unrelated, unnumbered pages a valid will in the state of Florida? I think the answer has to be no, based on the case law, based on the dispositive 4 corners analysis in this case. And so again, the probate court, keep in mind, was just tasked with deciding whether to revoke letters of administration. These letters of administration are simply to appoint a PR. Can we appoint a PR from a statement of wishes? The portion of this booklet that would have appointed a PR is blank. The only thing we know is that the decedent, best case scenario, would have liked to leave a discretionary decision up to his PR, up to his families and friends, to give the appellant whatever property he had. But that is not under Florida. There's no statutory preference for the promisee of some property to become the PR. There's no right to become the PR. And so you couldn't issue letters of administration to simply someone who was promised something. That's what this case boils down to. And that's why the probate court here properly revoked those temporary letters of administration it issued. So if there are no further questions, I would respectfully ask the court to affirm the probate court's order. Thank you.
Thank you. Rebuttal, 2 minutes.
Your Honors, I'd like to address the issue about the mandatory versus precatory language. If you look at the In re Frazier's estate case, which is cited in our briefs, the 5th DCA stated that oftentimes when precatory words are addressed to the personal representative, such words are interpreted as mandatory. So, and then if you look at the self-proving affidavit, the decedent fills in his name and states, "I, Emiliano Garcia, declare to the officer taking my acknowledgement of this instrument and to the subscribing witness that I signed this instrument as my will." That is the decedent himself affirmatively stating, "This is my will." He filled in that Antonio Gonzalez was his absolute inheritor. To find that language, absolute inheritor, is mandatory or advisory only, goes against what the decedent was actually doing here, which was filling out his will and stating who he wanted his inheritor, his beneficiary of his estate, to be, the only beneficiary of his estate. When it comes to naming a personal representative, probate courts appoint personal representatives without wills stating who the PR is going to be all the time. This is regular course in the probate court. So the fact that that is missing from this will is not does not invalidate it. And also the statute 732-502 at subsection 4 states explicitly that you cannot invalidate a will based upon the term of words used in the will. And that's exactly what the probate court did here. It looked into the will before admitting it to probate and found that language to be advisory. But that's a labor for after you admit the will. And so that is the error that is at the heart of this case, Your Honors. So what I would ask the court to do is to reverse the order of the probate court, as the evidence, the substantial evidence, shows that this was a validly executed will under Florida law and should have been admitted under Florida law. Thank you.
Thank you.